Hello again, it's Professor Harper, and today we're going to be talking about privacy, which intersects with journalism and the law in several ways. It's not a primary concern, but it can get you into trouble. So let's talk about the types of privacy. There's the publication of embarrassing private facts. There's physical and technological intrusion. There's something called false light privacy, and then commercialization. And we'll go through all four of these. So the right to privacy is not specifically addressed in the Constitution, although the Fourth Amendment does establish the right against reasonable search and seizure. And technological advances really have come into play with respect to privacy since the 19th century. In 1890, Louis Brandeis wrote an article for the Harvard Law Review in which he spelled out some of the technological problems. Photographs and newspaper enterprise have invaded the sacred precincts of private and domestic life, and Brandeis would become one of the most influential jurists in the history of the Supreme Court. The courts have tried to balance the flow of information against the right of an individual to maintain his or her privacy. So the first area is embarrassing private facts. So the publication of private information that could be highly offensive to a reasonable person and is not a matter of public concern is really what we're talking about here. So in 1975, Cox Broadcasting v. Cohn, the Supreme Court held that the news media could use the name of rape victims. In fact, most news organizations don't. But there is legal protection to use the name of rape victims. Another case which is influential here has to do with jury trials. And in Times-Mirror versus the San Diego Superior Court, an appellate court upheld that it was possible to deny access to the names of a witness to a crime. Other cases involving embarrassing facts, 1991 in Cohen v. Cowles, and this is one where it also affects confidential sources. The reporters promised to keep a source's name private. The editors overruled that oral contract and printed the name. And the Supreme Court agreed with the source who sued that the individual had violated his privacy. So be careful when you make those contracts on what you're going to do with the information and the name of sources. So be careful. Intrusion is the second one. Intrusion is the highly offensive invasion of another's solitude, either physically or by the use of technological devices. So technological devices is what we generally talk about. So that there is privacy in public places. A variety of state rulings generally protect the media in public places, but a woman successfully sued that her privacy was violated when her picture was taken in a restaurant, which is not a public place. And also, Jackie Onassis was able to keep a specific photographer through a restraining order so that he still could take pictures of her in a public place, but it had to be from a certain distance. The third area is trespass, which is anyone who enters private property without permission commits trespass. And there have been a number of cases involved here. So we talked earlier about Red Lion where the producers of ABC Primetime provided false information, but they also obtained access and therefore trespassed by providing this false information on applications. And some agreements while oral contracts, and this is where you get into kind of the mixed bag of interpretation. In 1999, ABC Primetime, actually it was ruled that they could use hidden cameras despite the fact that they had promised not to do so at a particular eye clinic. Again, this has to do with trespass, so that a salesperson crosses onto private property to ring the doorbell of a house. If the salesperson does nothing illegal and leaves when asked, he or she is not guilty of trespass. That's pretty much the same standard that was held in 1999 in Wilson v. Lane is that if you're asked to leave, you've got to leave, otherwise you're engaged in trespass. And this is what happened in Wilson v. Lane. We talked a little bit earlier, is essentially this was a ride-along with the Washington Post, and federal law enforcement went to the home of Charles and Geraldine Wilson looking for their son for violating parole. And in 1999, the Supreme Court ruled unanimously that the Wilsons' privacy had been violated by the ride-along programs. As I mentioned in news gathering, consent laws are important, particularly in terms of, one-party consent states means essentially that you can use hidden cameras. Two-party consent states essentially means you can't use hidden cameras. Pennsylvania is one of those two-party consent states, so you have to be very careful about audio and camera work. But there's an important case which involves a journalist in Pennsylvania called Barnicki v. Vopper, in which the journalist did not violate wiretapping laws by using illegally recorded conversations from a third party. So the out was the journalist did not violate the two-party consent law. Someone else did and gave that information to the journalist. False light is the invasion of privacy by publication of highly offensive false information about an individual with actual malice. That is, knowing that the information is false or with reckless disregard for the truth of the falsity. So if we know before publication that we're going to publish something and it's wrong, we're in big trouble. Another thing with respect to false light, courts usually weigh two factors. First, fictionalization in a factual presentation, and also distortion when parts of a story are placed or omitted or put in an improper context. Appropriation is the use of another person's name, likeness, or image without permission for commercial gain. That essentially means that you cannot take a photograph of Britney Spears and put it up on your website and gain advertising revenues from that without that person's permission. Now, there is something called fair use. So if there is a news story about Britney Spears, you can, in fact, use a likeness of her. Constitutional privacy. In Katz v. United States in 1967, the Supreme Court found that there's what's called a zone of privacy around a person and not a specific place. So therefore, the court ruled unconstitutional a wiretap on a public telephone booth. And so the zone of privacy was not physically that public telephone booth, but where that person was. And and that the zone around that person was protected. There's also constitutional privacy. The NAACP versus Alabama in 1958, the U.S. Supreme Court struck down an Alabama law that provided restrictions to membership lists. Griswold v. Connecticut allowed access to birth control information, but Roe v. Wade in 1973, the abortion ruling, ruled that people had privacy and a right to that privacy when she had an abortion. Freedom of Information Act is a federal law passed in 1966, and there are privacy exclusions here. Personal tax returns, personnel information, personal health data. Law enforcement data also are restricted under certain circumstances to protect individual sources of information, including crime scene photos. There are a variety of other privacy laws, the Driver Privacy Protection Act, which restricts access to driver's license information. It occurred after an actress was killed by a stalker. The Family Educational Rights and Privacy Act, or FERPA, restricts academic information, particularly grades, and non-criminal disciplinary information. That applies to anything at high school and colleges. Jurors can have their names restricted in some states, and there's also another restriction, the Health Insurance Portability and Accountability Act, HIPAA, which has come into place, which actually restricts access to health information. So, these are some of the issues involved in privacy. Some cross into the realm of journalism. Others are general privacy matters, and just please be aware of them, particularly false light privacy. That often is charged in combination with defamation and libel. So that if you place a series of facts or omit facts or publish facts that you knew were untrue, those are generally co-joined with a libel action. So that's it for now, and we'll see you online. Thanks very much.